For centuries, racial bias has been woven into the fabric of legal systems around the world. And in the United States, this history runs especially deep in the treatment of black defendants. From the era of slavery through Jim Crow segregation and into the modern age, laws and legal institutions were often explicitly or implicitly designed to treat black people as less than equal. Even after formal legal equality was established, for example, with the 14th Amendment guaranteeing equal protection under the law, the legacy of discrimination did not vanish. Judges, like all human beings, are shaped by the societies and cultures around them. They absorb prevailing stereotypes, assumptions, and narratives about race through education, media, community discourse, and institutional norms. When these racial attitudes are not actively examined and challenged, they can subtly influence how judges perceive black defendants, affecting everything from initial bail decisions to sentencing outcomes. Implicit bias, the subconscious associations people hold between race and certain traits, plays a central role in this dynamic. Many Americans, including judges, may sincerely believe they are fair and impartial, yet still carry unconscious associations linking black people with criminality, danger, or untrustworthiness. Scientific research using tools like the Implicit Association Test, IAT, has shown that implicit biases are widespread across racial and professional groups, regardless of individuals' conscious beliefs or intentions. Because these biases are not normally accessible through introspection, judges may not even be aware when they influence their thinking. For example, a judge might perceive a black defendant's nonverbal cues, averted eye contact, nervous gestures, or tone of voice, as signs of deception or lack of remorse, even when those behaviors are simply stress responses to courtroom pressure. In contrast, similar behavior by white defendants might be interpreted more benignly. This difference in interpretation may seem subtle in individual cases, but across hundreds or thousands of decisions, it accumulates into measurable disparities in outcomes. The structural factors embedded in the criminal justice system further magnify these individual cognitive biases. Prosecutors often bring harsher charges against black defendants and are more likely to seek mandatory minimum sentences, particularly in drug and violent crime cases. Defense counsel for indigent black defendants may be overworked, under-resourced, and unable to mount the same level of defense seen in cases where defendants have greater means. Judges operating in high-volume courts face intense time pressure and heavy caseloads, encouraging reliance on heuristics, mental shortcuts that substitute quick judgment for careful deliberation. When under duress, the human brain defaults to patterns and stereotypes it has internalized over time. Additionally, courtroom practices like pre-trial risk assessments, intended to be objective tools, can inadvertently encode historical biases if they rely on data reflecting previous discriminatory practices. In such environment, a judge might look at a black defendant's arrest history, patchy employment record, or neighborhood of origin and conclude, without conscious malice, that the risk of reoffending is high, even if these factors are poor predictors of individual behavior. These systemic pressures and the absence of robust safeguards against bias help explain why judges sometimes misjudge black defendants, not as isolated incidents of personal prejudice, but as predictable outcomes of larger structural forces. To understand why judicial misjudgment occurs, it is helpful to explore the psychological mechanisms that shape human decision-making. One such mechanism is confirmation bias, the tendency to search for, interpret, and remember information in ways that confirm pre-existing beliefs. A judge who unconsciously associates black defendants with greater risk may give disproportionate weight to evidence that seems to support that view. For instance, prior arrests, neighborhood crime statistics, or a defendant's demeanor, while discounting mitigating factors like character references, stable employment history, or credible alibi testimony. Over time, these cognitive patterns can ossify into expectations about how black defendants are likely to behave, reinforcing a cycle where bias begets biased judgments. Another powerful psychological force at play is stereotype threat. When black defendants enter a courtroom, they are operating in an environment historically associated with mistrust and disadvantage. The pressure of this context can elicit stress responses that affect communication style and behavior. For example, A black defendant might speak softly out of nervousness, avoid eye contact due to cultural norms about respect, or appear tense because they fear being misunderstood. A judge unfamiliar with the socio-cultural origins of such behaviors might misinterpret them as evidence of guilt or lack of credibility. At the same time, judges may be unaware that stereotype threat affects performance and behavior. Rather than recognizing the impact of systemic injustice on a defendant's courtroom comportment, a judge's internalized biases can lead them to view these behaviors through a deficit lens, assuming that the defendant is evasive or unremorseful. Real case patterns illustrate these psychological dynamics in action. Consider a scenario where two defendants, one black and one white, are charged with similar nonviolent offenses. Research consistently shows that black defendants are more likely to receive higher bail amounts, be denied pretrial release, and be sentenced to longer prison terms than their white counterparts, even after controlling for prior criminal history and offense severity. These disparities are not random. They reflect patterns that emerge across jurisdictions and over time, suggesting systemic bias rather than isolated misjudgments. Judges themselves often express surprise when confronted with statistical evidence of racial disparities, insisting that they do not consider race in their decisions. Yet the aggregate data tells a different story, one that reveals predictable discrepancies linked to race. In some high-profile cases, appellate courts have overturned convictions or sentences on the grounds that a trial judge's reasoning was tainted by bias, either explicitly expressed or implicit. In other instances, post-conviction reviews have revealed that black defendants were more likely to be perceived as dangerous or uncooperative based on subjective assessments that had little grounding in objective evidence. These examples highlight how human cognitive tendencies, such as anchoring on first impressions, relying on mental shortcuts, and misinterpreting stress responses, interact with structural pressures to produce misjudgments. Importantly, these are not stories of overt racism alone, but of how unconscious psychological processes operating within an unequal system can produce unjust outcomes. Recognizing the role of these processes is the first step toward developing strategies to mitigate their effects, whether through training, procedural reforms, or judicial accountability mechanisms. Addressing judicial misjudgment requires both individual awareness and systemic reform. At the individual level, judges can engage in bias training designed to help them recognize and counteract implicit associations. Such training encourages self-reflection, mindfulness, and the use of decision-making tools that emphasize objective criteria over subjective impressions. By learning to question initial reactions, especially when those reactions align with negative racial stereotypes, judges can slow down their thinking and reduce reliance on automatic judgments. Some jurisdictions have begun implementing programs that bring social science insights into the courtroom, educating judges about stereotype threat, communication differences, and the impact of historical discrimination on defendants' lives. While training alone cannot eliminate bias, it can make it more visible and manageable, particularly when paired with ongoing evaluation and accountability. Systemic reforms complement individual efforts by redesigning the structures within which judicial decisions are made. One approach is to improve pretrial decision-making by reducing judges' reliance on subjective risk assessments. For example, some courts have shifted toward bail systems that prioritize non-financial conditions for release, such as supervised check-ins or electronic monitoring, rather than high cash bail amounts that disproportionately burden low-income and minority defendants. Other reforms involve standardizing sentencing guidelines to limit disparities, while allowing judges to document and justify departures from those guidelines. Transparency initiatives, such as publishing regular data on bail decisions, sentencing patterns, and outcomes broken down by race, empower the public and oversight bodies to identify and address problematic trends. When judges know their decisions will be scrutinized in this way, it creates an incentive to adhere more closely to objective criteria and resist the pull of bias. Despite these efforts, significant challenges remain. Critics of reform often argue that judges must have discretion to tailor decisions to the unique circumstances of each case, and that overly rigid guidelines could undermine individualized justice. There is also resistance to the idea that systemic factors influence judicial behavior, with some judges insisting that they are colorblind and that disparities must result from defendants' choices rather than judicial bias. Bridging this gap requires not only data and training, but cultural change within the legal profession, a shift toward humility, continuous learning, and a willingness to confront uncomfortable truths about how race shapes courtroom dynamics. Long-term change also depends on broader social transformation, including addressing disparities in education, employment, and community resources that feed into the criminal justice system. Ultimately, the story of why judges sometimes misjudge black defendants is not one of simple villainy or isolated error. It is a complex narrative involving psychology, history, structural inequality, and institutional practices. By acknowledging the roots of these misjudgments, from implicit bias and stereotype threat to systemic pressures that shape court decisions, stakeholders can work toward remedies that uphold fairness and equality. Real case analysis reveals patterns that demand action, not denial. When judges, policymakers, attorneys, and communities commit to understanding and addressing these patterns, the justice system moves closer to fulfilling its promise of impartiality for all individuals, regardless of race.